Good afternoon and welcome to this Purchasing Legislative and Procedural Updates webinar. Today's webinar is being recorded and is scheduled to last approximately an hour and a half. At this time, everybody is in listen-only mode. However, as we go through today's presentation, if you should have questions, please feel free to type them into the chat box on the right-hand side of the page, sending them to the host and presenter, and we will address them before we move on. We'll also have a short period at the end of today's webinar to address any final questions you may have. An email was sent out on Friday to everyone who was registered with a copy of today's PowerPoint. Hopefully you were able to print that out to follow along. If not, we will be sending an email to all designated procurement officers in the next couple of days with a link to the recording, and we will be sure to include the PowerPoint again at that time, as well as a certificate of completion for anybody who chooses to view the recording online, so that they, as well as you guys, may receive an hour and a half of credit toward your 10-hour training requirement for fiscal year 2018. Of course, they will need to be sure to send that certificate back to us completed in order to receive credit. With that said, joining us today to present this information is Purchasing Division General Counsel Jimmy Meadows, and I will turn it over to him at this point in time.
Thank you, Samantha. Happy to be here. Happy to be able to share with you guys some of the changes that we've been able to implement in procurement law that are all going to become effective on June 8, 2018. And with that, let's just go ahead and get started. Okay, so some of you guys may be aware that, you know, this Senate Bill 283, which gave rise to a lot of the changes that we're talking about today, hasn't just been a recent effort. We've been working over the last 2.5 years to try to identify some of the major pain points, roadblocks in the procurement process, and figure out what we could do, you know, in terms of changing law to try to help make some of those a little bit easier, a little bit faster and more efficient. We had some initial success 2 sessions ago. I don't know, some of you guys may recall that, you know, in the past we had to disqualify bidders for what were, you know, classified by pretty much anybody that knew about them as clerical errors. You know, failure to send in the directory workplace affidavit with the bid would get you an automatic disqualification from a procurement. Failure to include your contractor's license number on the bid would have garnered another automatic disqualification of your bid, and then the same thing with the sublist submission. And so, you know, back 2 sessions ago, we proposed, you know, making those things curable, in effect, statutory change, and then we had about 10 or 12 other items included in that, and, you know, the legislature chose only to take up those 3 at that time. Well, this past session, we were able to reintroduce a lot of those things that we had proposed 2 years ago, and this time Governor Justice's office was gracious enough to lend his support to the effort, and so, you know, our Senate Bill 283 became a governor's bill, and we were able to implement a lot of those changes that we've been working on for a long time. And we didn't do it alone. You know, as I mentioned, we had support from Governor Justice's office, but we also had a lot of broad-based support from the agencies. And you know, you guys may know that we worked with a lot of you during our strategic sourcing meetings that we have with some of the larger agencies to identify the problems and try to help come up with some solutions. You know, general conversations with a lot of you folks out there that do procurement on a day-to-day basis gave rise to a lot of these suggestions. And of course, you know, there was some brainstorming, there was communication with the legislature in both houses, and overall this was a very collaborative, thoughtful effort as to how we could make procurement better for all of us going forward. So, you know, why are we doing it? We want to make the procurement process faster and more efficient, and to eliminate a lot of the most common problems that we see on a day-to-day basis, while at the same time maintaining the integrity and the fairness that are the hallmarks of public procurement. So I mentioned those already. Something else that we did, it's not a legal change, but a couple of years ago we actually created the Section 9 opinion request form. That's a form that if you're not sure whether or not what you're about to do is included in Section 9 or not, and would be thereby exempted from purchasing, you can take that form, fill it out, and send it in for an official opinion. Think ethics opinion, think an IRS, letter ruling. That was kind of what we were shooting for. In instances where you're not sure, ask us before the inspectors come out and look at it and tell you that's the wrong decision, right? That's kind of the idea behind it. So that was implemented a couple years ago as well. So Senate Bill 283, how's it going to affect you? The first thing, it's worth noting, we modified West Virginia Code Section 5-22-1. That's the code that deals with construction. And two of the things that were modified here, we consistently heard from all of the agencies out there that when they have maintenance and repair activities, think here, guys, HVAC maintenance, think elevator maintenance, recurring, perhaps plumbing repairs, anything where a system breaks down and you need somebody under contract to come in and fix it, but you're not sure what the fix is going to require, right? That's kind of what we were targeting here, allowing an agency the ability to get somebody under contract so that they could then just pick up the phone and say, hey, it broke, come in and look at it, right? That's the idea. And there's some limitations on that we'll talk about here in just a second. And then there's also the additions and alternates have been modified, and we'll hit on that in just a second as well. So let's look at this particular definition was added to 522. Previously, construction project was not defined at all, and so we added a definition here that specifically defines it, and it says that it will, go to the next slide there, include a repair and maintenance of an existing public improvement that's recurring or ongoing in nature and that are not fully identified or known at any one time shall be considered a construction project. So what we're doing with that language right there is saying that maintenance and repair activities can be included within a contract under 522. In the past, we had taken the position that it couldn't be because of the way the statute read. So we modified that to specifically allow for open-ended repair and maintenance type construction. This would not allow for, open-ended building of buildings, right? That wasn't the goal and certainly isn't what the statute authorizes. So it's limited to maintenance and repair. Now the second part that's highlighted below is another limitation. This was added not on the front end, but through the legislative process there was some concern by legislators and other interested parties that having the ability to do this open-ended construction, repair and maintenance type activity on an unlimited basis, they felt like perhaps that was problematic, and so they proposed a $500,000 limitation on that. And so the thing you need to know about the $500,000 limit is that it is the entire contract, not just the first year, not the second year, it's the whole thing. So if it's a 4-year contract, it's 4 years, and you can't spend more than $500,000 on those maintenance and repair activities under the contract. So should prove to be helpful, though. I know a lot of agencies that do construction are happy to be able to take on that open-ended maintenance and repair, and we're happy to be able to help. The additions and alternates. We see that a lot. I know we've seen it in some general services contracts. I've also seen it in some of the contracts with the National Guard. And, the idea behind that, for those of you that don't know, is that in some instances, if the construction comes in at a certain dollar amount and there's money left over, well, the contracting entity may want, they may want to be able to do more with the remainder of the money, and so they'll add alternates or additions to the project that they can take advantage of depending on where bids come in at. That has now, it used to be 7, you could have 7 additions or alternates. That's been reduced to 5, and I probably should say that this is not something that the Purchasing Division asked for, but it was something that various interested parties in construction felt like they wanted to see. So as part of the Senate Bill 283 and the changes that we were trying to accomplish, this particular change was introduced as well, and it happened to stay in. So adults, additions alternates were reduced from 7 to 5. Previously, you could accept those out of order if certain conditions were met. That's no longer the case. You have to accept them in the order they're listed. So you can accept alternate number 1, but you can only accept number 2 if you've accepted number 1, and you can only accept number 3 if you've accepted number 1 and 2. So you get the idea all the way up to 5. And it's also important to note that the expiration of those alternates happens after 90 days, and that's 90 days from bid opening. So, you know, not exactly clear on how, if it takes longer than 90 days from bid opening to award, you know, what the impact of that would be on the additions and alternates. Arguably, they would be void, but, you know, perhaps not. So, anyway, they do expire after 90 days. And my understanding is that wasn't intended to really be a front-end issue. It was more along the lines of not requiring the contractor to perform an addition or alternate that's added by change order, you know, 2 years later, right? The presumption is those costs have changed and things like that. So that was the intent, but the unintended consequence in some, like in this case, is that, you know, if for whatever reason perhaps funding is delayed and it takes longer than 90 days to award, what happens to that add-alt? Well, I'm not exactly sure, but we'll be looking into it. So what documents would be modified by these 2 changes? Well, the construction templates, you know, they had the add-alt language in there. That would have to be modified. The HVAC template and the elevator maintenance template, those of you guys that use those know that they had a prior limit of $25,000 attached to corrective maintenance. Now, there's really no distinction between corrective maintenance and preventive maintenance. It's going to be, you know, a total contract for maintenance, and it's going to be limited at $500,000. That change has been made. And, of course, there's changes to the Purchasing Division terms and conditions and also to the Procedures Handbook. And we can take a look at some of those changes here in just a few minutes. Request for proposal is another area where there's been some significant modification. And, you know, one of the common problems that we see in the request for proposal is this idea that, you know, agencies, in spite of what the law required, which is a comparison of the vendor's proposal to the request for proposal itself or the terms contained in it, what agencies want to do and evaluators want to do is compare the bidders against each other. And it's a very natural thing to do, right? I mean, when you're trying to figure out what's the best value or the best solution, you're going to say, oh, well, this guy does this, that guy does that. I think that's better than this. So, you know, you want to allocate points accordingly. And the old RFP law simply didn't allow it. And so you probably had more than one conversation where the purchasing division buyer is telling you or your agency, no, you can't compare the 2 against each other. You got to compare back to the specifications. And it can be a little challenging to do that. So then the other thing that, well, let me just say this, that the statute was modified to allow for this comparison among vendors, and we'll see the language here in just a second. But the second thing that was modified in RFP in a legal sense is that this ability to compare one vendor against another allows for a best-in-class solution type analysis, whereas previously, you know, the thought was that if you set a desirable requirement, let's just call it a desirable, and the vendor meets that desirable, they get maximum points for that. If the vendor exceeds that desirable, they don't really get any extra. And so that, you know, precluded the idea that somebody could provide you with the best in class and somehow benefit from it. So that doesn't really seem like the best way to evaluate or the best way to get, you know, best value for the state. So statute was changed to allow for that. There were also some non-statutory changes that we implemented. After looking at RFPs pretty in depth, it became clear that we're being asked at the purchasing division on an increasing frequency to allow RFPs for lower dollar level procurements. Specifically, you know, the limit as it exists now is $250,000. That's kind of the cutoff point. Well, we noticed that we've been getting an increase in requests in the $150, $125, $200,000 range, and we've actually even approved 3 or 4 of those. So the question we asked ourselves was, all right, if we're willing to approve it 3 or 4 times, does it really make sense to have a limit at $250,000 anymore? And the decision was, at least, you know, with regard to the next few years, we're going to try that limit at $100,000 instead of $250,000 and see what the results are. So the limit's been reduced to $100,000. We also are going to allow, and this is not necessarily a change so much as it is a clarification of policy. You know, the question is, all right, the vendor has a mandatory requirement. Obviously, you throw them out if they don't meet that. But what if one vendor's better at meeting the mandatory requirement than the other, right? How do you deal with that? You know, we ask for some piece of, you know, computer equipment, and it has to process at a certain speed, and so one company proposes this device that's, you know, the size of the room you're sitting in, but technically it'll meet that speed. And then the other vendor proposes the device that'll fit in your hand and meets that same speed requirement. Obviously, you know, the one that will fit in your hand is much better, but under the old RFP format, there was some confusion as to whether or not you could score that mandatory. Well, we've clarified that with the new RFP template to allow for that type of, you know, comparison or type of scoring. And it's just that scenario, right? If the vendors don't meet the speed requirement, again, we're talking about the hardware example, if they don't meet the processing speed, they get thrown out. They don't continue on in the RFP evaluation. However, if they do meet it, then the agency is going to have an opportunity, if they so choose, and include it in the RFP evaluation metric, to actually compare and score according to how well the one vendor met the mandatory requirement as opposed to the other, and if there's benefit and value there, you know. Also, we eliminated the copy and paste forms at the end of the RFP template, and we matched up Section 4 with evaluation criteria. So I think, let me see what this next slide is. Here's the statutory language we changed. We added the part highlighted in red, the degree to which a proposal exceeds the other proposals on technical merit. That's what gives us the ability to score one proposal against the next and to take into consideration a best-in-class solution. So some of the documents that were modified, Purchasing Division Procedures Handbook and the RFP template. So what I want to do real quick is to pull up the RFP template. So if you'll bear with me for just a second, I'm going to share with you the screen, and then we're going to find RFP template in here. And I want to kind of walk you through what we've done here. And I really like, I think we're just going to jump straight into Section 4, which is where a lot of the nuts and bolts happen in terms of RFP. We modified it. The first thing you're going to talk about, and it was in the old RFP template, but the background and current operating environment, you're just going to kind of lay it out for the vendors, right? And you also are going to want to include, check out that last sentence, you know, a description of how the agency sees the operating environment changing as a result of the RFP. I mean, it's one thing to say, hey, you know, we currently accept bids in paper format, and to let all the vendors know that, assuming we're trying to buy some sort of bidding process through this RFP. But if we plan to change that and go completely paperless, well, you need to let the vendor community know that in the future, that's not going to be how we operate going forward. So just some clarity as to what we're looking for in that section. And then next, Section 4.2, we talk about, this is where a lot of the change happened, right? So this was reorganized to me to make it make a little bit more sense. You're going to list your goals and objectives, and that's your traditional, you know, here's what we want to achieve, and then you know, the vendors are going to propose how they do that, and you score that. That's the, what do we call it, the non-mandatory scoreable section in the prior RFP format. And I think the real change is in Section 4.2.2, mandatory project requirements. And note, vendor should describe how it will comply with the mandatory requirements and include any areas where its proposed solution exceeds those mandatory requirements. This is again, that ability to say, okay, both of you met. Now which one is better at meeting that requirement? You can do it in less time, can do it with less resources, et cetera, et cetera. And right here, the approach methodology that the vendor uses to comply and the areas where the mandatory requirements are exceeded will be included in technical scores where appropriate. So this has been allowed in the past. There's been a few RFPs specifically where this kind of an approach was taken. So again, it's just more clarification of policy, but just so that everybody's clear, we spelled it out in such a way that it's hard to miss. Qualifications and experience, we took that same approach. Okay, so 4.3, this would be your traditional, desirable. What would we like? We'd like a PhD candidate, right? And you score that. If somebody comes in and they're less than a PhD candidate, obviously they get points deducted. If they're, if they meet that requirement, then they're gonna get all the points for that particular category. And this is probably a good point to also talk about how you compare vendors against each other. If you say, I want somebody with I would desire somebody with a PhD in, molecular biology, and somebody comes along and they propose, well, not only are we going to give you a PhD in that, he also has a PhD in chemistry and physics as well. In that scenario, the way we would do that cross comparison, let's say a second bidder then proposes only somebody who has that PhD required, right, or not required but desired. What you would do in that instance is provide the vendor with the extra, the one that's better than the other one. They're going to receive the full amount of points allocated to that particular desirable requirement, and you would deduct points from the other score, from the other proposal score, based on one being better than the other. So basically, in a situation where at least one of the bidders exceeds the desirable requirement, that particular bidder that's the best in that category is going to get all the points, and everybody else is deducted accordingly in a manner that the evaluation committee sees fit. So we're still doing deductive scoring, but it does allow you that opportunity to take into consideration best in class and to evaluate the proposals against each other. So that's kind of the framework of how this works going forward. And then the same thing with the mandatory requirements we talked about earlier. We added that same principle to the experience. So in 4.3.1, you tell them what you want, what you desire, right? That's where you put, I want a PhD. In the mandatory section, that's the section where you have to ask yourself, am I willing to disqualify every single bidder if they don't meet this requirement? If the answer is yes, then it goes right here. And so let's just say, following the educational example, what's the absolute minimum? The absolute minimum we're willing to accept is somebody with a college education. What do we prefer? PhD. What do we absolutely have to have? We have to have college degree, right? So in this section, then, you could list that requirement as college educated, and then just like in the mandatory section we saw earlier, there's going to be that opportunity to score individuals that exceed that experience requirement in some way. So that's kind of how it was drawn up. And then something that we noticed over the years that we were going back and forth with agencies a lot on is the whole idea that Section 6.2, the evaluation criteria, has to match Section 4. So we just went ahead and did that, right? We have the project goals and objectives approach, or section, the two subsections under it, qualifications and experience, two sections under that they match up, one for one exactly as they are above. Now, something that agencies can do if they want to is add subsections, right? Under approach and methodology, you can have, goal and objective 1, goal and objective 2, goal and objective 3, just like we have above, and assign subpoints into those categories. But, obviously that can't happen until the RFP is actually written and you know what you're going to put there. or you can go with a generic approach and leave it just like this, fill in your points and move forward. Then the other thing that I want to point out is we didn't change the cost formula, but we did explain it a little better so that bidders will have an easier way of understanding what it is exactly we did to come up with a cost score. So that's in there also. And then, as I mentioned earlier, we eliminated that whole cut and paste from Section 4 into the attached sheets, right? I mean, what we've seen is that the vendor community, they didn't really use those anyway. They just kind of retyped the RFP requirements and different parts of it into their own proposal format, and we've been accepting that, right, as we should. So just really didn't see a need to make the agencies continue to fill in those blanks and try to assert that the vendor community should as well. Guys, if you all have any questions as we move forward, please feel free to ask. We'll answer those as we go because there's a lot of material that we're covering today. And the next thing we're going to talk about is direct award, formerly sole source, or I guess will be as of June 8th. Probably the hardest thing about sole source is that if taken literally, it means that there's only one source in the whole world that can do this thing that we need done or provide this thing that we need provided. And that's really hard. And 90, I'm going to just throw out a number, I mean, it's a huge percent of the time, we'd see agencies basically come in and say, well, are they the only source? No, they're not the only source, but nobody else can do it as cheaply, or nobody else has the background knowledge, or nobody else can, for whatever reason. Well, that's not the definition, right? And we've had a lot of discussions and frankly, disagreements with agencies over the years about whether or not something that they want is actually a sole source. And we agree with you. We don't disagree that nobody else can do it at that same price point or that nobody else can reasonably come in and obtain the knowledge they need to do it quickly. It's just that the law simply didn't allow us to move in that direction. Well, the great news is, after June 8th, it will. We've modified, you can see that language in red there, we've included an additional requirement. So obviously, if there's literally only one in the world, that's going to continue to be possible grounds for making a direct award. But if no other source would be willing or able to replace the existing source without a detrimental effect to the spending unit, then you can also make a direct award. It's probably worth noting the reason that the name was changed is that sole source implies only one source, right? And that's not what we're saying here. With a direct award, we're saying either that there's only one source or there's literally nobody else, or not literally nobody else, that nobody else would be willing to do this without a pretty significant detrimental effect on us, the state. And if you can make that case, then we're going to go forward with the sole source posting. We think that's going to make it significantly easier to get a direct award approved in the future. So what documents are modified here? We've got the Purchasing Division Procedures Handbook is modified to reflect this new understanding, new law. The WV65 direct award has been changed. And so something else that we did, we noticed that a lot of agencies, when they do the sole source posting now, they would fill out the WV65 to obtain approval, and then they would complete the SSD form, or sole source determination form, and they would essentially use the same language from the WV65 and post it onto that form. And so, we looked at that and said, why don't we find a way to modify the WV65 so that it serves both functions? You fill it out once to get approval, and then that same form is the basis upon which the sole source posting happens, right? So one less form that you guys are going to have to fill out on the direct award process as we move forward. And then conversely, we noticed that there was not a corresponding form at the agency delegated level, right? There was no WV-65 that agency procurement officers could use to justify the direct award purchase. Well, we created one for you. We essentially made a duplicate WV-65, tacked an A on there, and said, okay, let's change, references to purchasing. We'll change that to agency procurement officer, and that will allow the agencies to properly document and justify, and then post, the direct award. That's going to take a while to get used to, guys. We've called it sole source for so long. Now we're changing it for good reason, but calling it a direct award is going to be a little difficult moving forward, just purely out of habit. So at the agency level, fill out that WV-65. Post it in OASIS with all the stuff that you would normally post if it's above the written limit, and we hope that'll be beneficial. So let's take a look at that real quick. So the WV-65, we'll start with that. We modified the language just a little bit. We're also going to be asking agencies. We've seen an increase in software as a service on item number 1 here. That's essentially cloud, or one facet of cloud computing, and we need to know when that's the case. So we've asked agencies to identify that, but then justification showing direct award is in the best interest of the state will continue to be a line item. But item number 3 is where it really changes a little bit. You'll see we have a box that says competition is not available from any other source. That's the traditional sole source, right? That's the literally nobody else in the world can do this. And then you would need to show how your agency has attempted to identify other sources from which this purchase can be made. Or, in cases where it's appropriate, you can also check the second box that says no other source would be willing or able to replace the existing source without a detrimental effect, et cetera, et cetera. And then the expectation is that you're going to explain how it is that that statement is true as well. And if you don't fill that out, we're going to have to send it back. We've got to have that explanation in there for this to work. And then, of course, there's other information that's statutorily required to go with the posting under items A, B, and C there. The time period for delivery, the price, and any limitations that a competing vendor would need to satisfy. This isn't going to change some of the other requirements in what used to be direct or sole source. We're still going to want to see all contract documents that you have with this. We're still going to want to see a quote. That's going to be how you get the price and things like that. But you're not going to have to fill out the SSD form anymore. So then on the WV-65A, the agency delegated, you can see this form should be used to justify all sole sources from $2,500.01 to $25,000, and then same information is required, but you'll notice here is the agency procurement officer that is the one that approves the or direct award. Any questions on any of this so far? Okay. Secondary bidding, we introduced a statute and it got approved. It modified some of the secondary bidding law. The master contracts previously were limited to 1 year. They're now going to be 3 years. That should make secondary bidding fairly more appealing. We also increased the dollar limit to $1 million per order. Previously, it was $50,000 for most commodities and then $1 million for technology equipment. And the legislature decided that $1 million across the board was probably not unreasonable, and so they modified the law. And then we changed the names to try to make it clearer. So the initial step is the establishment of a pre-qualification agreement. That's where you send out the solicitation and ask for bidders to submit their qualifications. The ones that are qualified get included in their, in the pre-qualified pool, so to speak, and then you send your solicitation to those individuals, and you have a delegated pre-qualification bidding after that.
I would say finish this and then go back.
Okay. We have a question popped up, and we'll answer that here in just a second. The secondary bidding documents that were modified is the procedures handbook. I think that was it on the secondary bidding. Yeah, next is department. So we have a question under Q&A, and bear with me a minute as I try to figure out the technology.
Yeah. That's right there. Just
okay. So the question is, say the reason is pricing. A company can replace the whole system for $50,000, but just purchasing an update would cost $20,000. Do you have to get bids from 2 other companies to replace the value? All right. That's not a great case. $20,000 to $50,000 is not a very big price difference. Personally, if I read that, my first thought would be that's probably not enough of a difference to say that it would be a detrimental effect on the spending unit. You need to take that out to bid and see what the market actually does, right? But let's change those facts a little bit. Let's say, it's going to cost $1 million to, have somebody else come in and replace this system, or you can continue with your existing for $20,000. It's a whole lot more compelling case, right? I mean, in that scenario, it'd be hard to argue, provided that you had some basis and proof that, the $1 million is the cost to replace everything. That's a scenario where I think the direct award gets approved. Cost differences of $20,000 to $50,000, we see differences like that all the time, and system replacement. It's hard. I guess the best way I can put it is it's really hard to make the case that on that small of a price difference that you shouldn't go back out to bid for that, because you may be able to get a whole new system, and if the vendor really prices it to win the work, maybe what it really comes in is $20,000 to $30,000, and then the question is, would it be better to have the whole new system for $30,000 or a continuation of the old for $20,000, right? It's got to be a significant price difference in order for that to be the basis for direct award, in my mind at least. So we have any other questions there?
Mm-mm.
No? Okay.
Oh, wait. Yes. If you keep scrolling down, will the ARFQ and OASIS be used as the posting procedure document at the agency level? Oh, it may not be shown. Okay. I'll go ahead and read the question aloud. It's not showing up on Jimmy's. But will the ARFQ and OASIS be used as the posting procedure document at the agency level?
And I assume that relates to sole source, since we were talking about that just a minute ago. I have some of the buyers in here and some of the inspectors, and so Tara's shaking her head yes. I mean, we're going to use the same mechanism that we always have in the past. The only thing that's going to change is we have the WV65A that you fill out to justify the sole source procurement for your own records, right? I mean, this is what Greg and the inspectors are going to be looking for when they come out to see the sole source postings that you've done at the delegated level. They're going to ask, where's the WV65A? All right. Samantha, if you don't mind, just whenever one question pops up, let us know, and we'll address it. So moving forward, some of you all may be familiar with some of the recent criminal indictments and convictions that have happened. One of them in particular was the indictment and subsequent conviction of individuals involved with the firm Bayless and Ramey. They're doing some engineering work, and then there were several others, the Dennis Corporation and the individuals that were, working for those entities. It brought to light some deficiencies in the debarment statutes, one of which is that 4 of the 8 debarment grounds rest on conviction. Well, in criminal cases, in a lot of instances, the individuals will, well, let's start with the companies. The companies will enter into a deferred prosecution agreement, which basically is an agreement between the prosecutor and the company that if the company does these certain things, the prosecutor isn't going to charge them with a crime. They're not going to prosecute a crime. They're basically going to emerge from the deferred prosecution agreement with no criminal conviction or record of, criminal activity. So right off the bat, that eliminated 4 grounds for debarment that we had to work with. If you look at the individual, in a lot of cases, the individual might plead guilty, but that guilty plea is not a conviction until the case is finalized, or at least until the judge, does a few things procedurally that would solidify that guilty plea. And we've all probably heard of pleas changing in the middle of the case. So the requirement that a conviction be obtained was certainly created some challenges that we hadn't seen in the past. So as a result of that, the state legislature, started an investigation. At the same time, the purchasing division had these efforts to help make the procurement process more efficient. So we decided, why don't we go ahead and address this issue as well? So we expanded by statute the definition of conviction to include guilty pleas, deferred prosecution agreements, nolo contendere pleas, and lesser included offenses. Just to basically say, hey, listen, if you're going to admit to wrongdoing in a guilty plea, or if you're going to, nolo contendere is a legal word. It means I'm not contesting it. I'm not admitting it, but I'm not contesting it. Well, guess what? In terms of debarment, that might as well be an admission, right? So moving forward, we're going to have these additional grounds to, pursue debarment. And then in addition to that, the statute also increased related parties, specifically defines it. Well, let me step back. The old debarment law said you could only extend debarment to a related party if there was sufficient grounds to, in a legal phrase, pierce the corporate veil. Basically, you had to show commingling of funds, you had to show a disregard of corporate form, you had to show a lot of other things that was particularly burdensome in the debarment realm. So we eliminated that and said, all right, if you're a related party as defined here, we can extend that debarment to your company or person if the director deems it appropriate. So just made that process a little less challenging. And the reason is we've seen in some cases you debar a corporate entity. What do the people do? They close down that corporate entity and they start another corporate entity. And with the law as it is, corporate entities are treated as their own separate legal thing. So it was really difficult to get those individuals and stop them from doing business with the state. This ought to help with that. Just a sort of a housekeeping note on debarment. The WVOA system does not automatically check debarred status at the state level. It does at the federal level, but not at the state level. So before you award a contract, you're going to always have had to, but will need to continue to check the state debarment page just to make sure that the vendor you're awarding to isn't debarred. Currently, there are 13 debarred vendors. That's up from 3 2 years ago. So we've had quite a few in recent years based on, criminal convictions and various other things. Again, check the website prior to awarding a contract to make sure they haven't been debarred at the state level. Interestingly enough, also, debarment extends not only to procurements handled by the purchasing division, but it casts the net very broadly. It hits highways exempt purchases. It hits municipality purchases. It also hits, I believe, at the higher education and various other, levels. So just check that out. Vendor preference, another modification to the law. Vendor preference in the traditional sense has been eliminated in all but 2 instances. The only places where vendor preference survived is in automobile purchases and in the highways equipment, or equipment related to highway road construction. So in those 2 instances, vendor preference will still continue to be evaluated. And then that same section of code was modified to impose a reciprocal preference on the vendor community. And probably worth mentioning how that works. Essentially, if a West Virginia bidder is bidding on a solicitation in West Virginia, And also, at the same time, a Pennsylvania bidder is bidding on that same solicitation, and Pennsylvania has a vendor preference that they give to their in-state vendors. Well, when that Pennsylvania bidder bids in West Virginia against a West Virginia bidder, we're going to give the West Virginia bidder the same preference that the Pennsylvania bidder would get in their state. That's a mouthful. I think it's a little easier to understand if you perhaps write it out. But basically, if they get a preference in their state, we're going to use that against them here and give that same preference to our bidders in our state. And that will require that the purchasing division put together a list of states with bidder preference, and so that we can utilize that going forward. And I think Oregon has pretty much done that, so we'll be using that to start with, and then we'll have to maintain that as we move forward. So what changes does this create in the bidding process? The vendor preference certificate. We've added a slot on there for the bidder community to check that they want the reciprocal preference, right? It only applies to West Virginia bidders, so they're going to have to, when they check that box, they're essentially confirming that they're a West Virginia bidder. Obviously, we'll have to check that to make sure before we give the preference out, but in general, that's how it'll work. The handbook is changing to account for these new procedures, and as are the agency terms and conditions. And it's probably important to note there that if you pull up the agency or the terms and conditions, both purchasing and agency, it doesn't make sense to include the vendor preference certificate on every solicitation now, because in most cases it doesn't apply, right? So what we've done is included in the vendor preference term a link to the vendor preference form. And so if a bidder is still interested in obtaining that preference, they're going to have to print the form, check the box, and then send it in, rather than us automatically attaching it to the solicitations we send out. The requirement that the request be made in writing with the bid hasn't changed. That particular part of the statute remains intact. But in general, we have, we will have less instances where vendor preference would apply. It looks like we have a question as well. So the question is, to verify residence would be to check SOS website, and they would be registered as domestic, correct? So I think this question is getting at, how do you determine whether or not it's a West Virginia vendor? Well, one of the first things that we do at purchasing, or at least our buyers do, is they look to see if this vendor is, if you get on the Secretary of State's website, for those of you that don't know, they have a business organizations database search, and you can type in the name of a vendor, and it will display a lot of information. And some of the information that includes are, a list of the officers of the company. It'll include, whether or not that company is registered as a domestic corporation, meaning under the laws of the state of West Virginia, or as a foreign corporation, meaning under the laws of another state. I always thought that was weird, that foreign in this case means outside of West Virginia, not outside the United States, right? But nevertheless, that's what it means, foreign to West Virginia. So an Ohio corporation would be foreign in that sense. So do you check, is that where you look to see if they're a West Virginia vendor? Well, that certainly helps. And chances are, if you look and they are a domestic West Virginia corporation, you're also going to see that their officers are in, an office that has an address in West Virginia. That would also show up on the Secretary of State's website, along with some other things. To really get down to domestic or to West Virginia vendor or not, the Code of State Rules actually has a four-part test, and you'd have to actually run through that test to determine it. But in most cases, if you see that it's domestic, probably the other pieces are going to fall into place. And if you have any questions about it, it's one of those things you have to look at on a case-by-case basis. So certainly your purchasing buyers, happy to work with you on that, as am I. But yeah, that's always a good starting point. Check the Secretary of State's website and see whether it's foreign or domestic. In most cases, if it's foreign, they're not going to qualify as a West Virginia vendor. And in most cases, if they're domestic, they probably are going to qualify. So, great point. We made a couple changes to surplus property law. One of them, we noticed that there was a problem. A lot of some of the older assets, you know, it may have been purchased 20, 30 years ago. Over that period of time, the asset continued to exist and continued to be used, but the account from which it was purchased, the account where the money for the purchase came from, has been changed or no longer exists. Well, that's a problem because surplus property law says that you have to reimburse the account from which the purchase was made. And if that account is gone, we have no mechanism at surplus to, you know, send that money back. So we asked, and the legislature was gracious enough to give us the authority in those instances to reimburse another account that the agency designates. So we'll be able to give that money back from the sale of property in more instances than we have in the past. And then the other change is that previously the valuation of state vehicles when they're sold to surplus had to start at the NADA loan value, which my understanding is that's lower than the fair market value. And we asked, and the legislature agreed, that that starting point should be fair market value. And so that will be the starting point moving forward. And that's fair market value is determined by an independent pricing guide, like think Kelley Blue Book or something like that. This is a big one, standardization. You know, in my 8 years here at the purchasing division, I would say this inability in the past to create a standard has been the most fought over issue. I mean, we'd see specifications come in that clearly favored a brand or vendor. We'd see, you know, efforts to disqualify a bidder that bid the item that you didn't want, right, a different brand than what you wanted. And just that back and forth eats up a huge amount of time and takes a lot of resources to try to handle that. So, and then in other instances, we know that agencies, they feel like having the best is absolutely necessary. Now, they want to get the best price for that particular commodity, but it needs to be the best. And one example that we went round and round over was bulletproof vests. And I get it, right? If you have people's lives on the line, you want them to have the best. So there needs to be this ability to evaluate the commodity and to determine which one is the best of those that you have. And then once you do, to go out to bid and get the lowest price on that brand you've identified. And so we asked a lot of agencies what their thoughts were on this and how it should be accomplished and would it be helpful. And, you know, overwhelmingly the response was yes, we'd absolutely love the ability to standardize. And so we drafted legislation that we thought had the best chance of passing through the legislature, and fortunately we're successful in getting that done. So you can now standardize if you follow the process that's laid out in West Virginia Code Section 5A-3-61. It essentially eliminates, once you've done that, you've eliminated the need to specify or equal, and you can literally, you know, let's just say Cisco routers. If you've established that as your standard, you can put together a solicitation and say, I need a Cisco router, and the purchasing division is going to say, great, I see where you've standardized on that, you ran through the process, it's been approved, we're going out to bid for Cisco routers and no or equals required. So that's kind of the goal there. Go to the next slide here. Now, it's not, you know, as with everything, there are limits. It only applies to commodities. We can't standardize a service. It must be a core function of the agency. You know, you can't stand. So some examples I would give, you know, for like general services, perhaps the standardization is on, you know, control systems for HVAC equipment, right? Because GSD's core mission, among other things, is to take care of the grounds and heating and cooling systems and things like that. Perhaps with DHHR, it's some medical device that they standardize on, or you know, I mentioned bulletproof vests. That's certainly a function of the DMAPS agencies and their, you know, their mission. So in instances like that, those would be examples of what a core function is. You're going to have to show that the standardization will save time and money, and it can't be, well, standardization is going to let me save time in the procurement process. No, the law says that's not where we go. It's got to save time and money without consideration given to any increases or decreases in the procurement time. It's got to be a commodity that requires some sort of testing or evaluation, or a commodity that has to be interoperable with, you know, existing things. And the standardization is going to have a 4-year limit, right? So you don't get to standardize today and allow that to be the standard for the next 50 years without going through that process multiple times over the years, every 4 years, in fact. So what's the procedure for this going to look like? Well, the first step is that the head of the agency is going to request approval for standardization from the purchasing division. So head of the agency would essentially be like a division director, or if it's being bid out at the cabinet level, perhaps a cabinet secretary or somebody like that. They're going to, once approval is granted, you know, you'll establish an evaluation committee, and that evaluation committee is, you know, they'll be doing the non-conflict type forms and thinking about how this will be evaluated. You're going to advertise this intent, you know, to this need for standardization as a request for information for 30 days. And it has to include a notice of what you're doing. It has to tell interested parties how to submit their products for consideration. It has to explain how we're going to evaluate and actually come down to a standard. It has to have a deadline for submission, a decision date, you know, a testing time period. Basically, we've got to make this open and fair and let the vendor community know how it's going to work so that if they want to participate, they can. Once that advertisement's out there for the requisite period of time, there will be an evaluation/testing period. And the evaluation committee obviously is the one that's going to be undertaking that. After the evaluation has been completed, you'll do another advertisement, an advertisement of the intent to standardize for 15 days. And during that time period, you're going to receive comments from the vendor community. Request for comments has to be included in the RFI. And then once that's completed, the head of the spending unit is going to notify purchasing division of the decision that's been made. The purchasing division is going to post that decision on its website, and then the spending unit will notify the unsuccessful participants within 5 business days that they've not been selected as the standard. And then any appeals to that standardization process or selection will be made to the head of the spending unit that's made the decision. So what documents are modified here? Obviously, the Purchasing Division Procedures Handbook is going to include a new section on standardization. The agency purchasing terms and conditions have been modified just a little bit under the provision that talks about alternates or equal requirements. We have a little checkbox that says no, this procurement is governed under that code section, and so or equal is not required. So we'll want to see that checked if you are in fact operating under a standard that you've established per this code section. And we created 2 documents to help get through this process. One is the standardization request form, and the second one is the standardization notice form. And I think we'll have those posted on our website after June 8th. You can take a look at. Architectural and engineering procurement, we had a modification to that. You know, let's see, 5G13 is over 250,000. I'm looking at Tara. That's correct, right? Let's assume it is. And then 5G14 is the under 250. But the under 250 procurement method had a provision that said, you know, if such circumstances exist, you know, public safety could be compromised, et cetera, you can bypass the whole, you know, 5G process and go directly to one bidder. There was no, we call that internally the emergency provision in 5G, and there one was not present in the over 250,000 procurements, 5G13. So we asked, and the legislature agreed that, you know, you probably need that, right? In instances where you have massive flooding, you have other structural problems, you need an architect or an engineer to come in there as soon as possible. There needs to be an ability to obtain those services on an emergency basis, even if the total cost of the project is going to exceed $250,000. So we got that particular provision that you see here added to 5G13. We also cleaned up the EOI template just a little bit. Not anything really significant, other than we did match up the section, you know, the evaluation section with the points, so that there's a clear distinction between the two. All right, we have a question.
If you can see it on yours or not.
Just go ahead and read it out.
Okay. Are we ever going to consider adding a I can't say that word, caveat? Okay. Are we ever going to consider adding a caveat where if an item can be purchased direct from the supplier, presumably online, cheaper than any bid that the agency receives, the agency can then purchase direct from the supplier?
Well, it's something to think about. And I'm guessing in most cases we're talking at the delegated level, because you know, rarely do you see that happen at the central level. We are actually going to open up the verbal bidding and actually allow for screen prints from websites, and then a subsequent purchase could be made from the verbal bidding through that. We'll talk about that in a little more detail later. But I think there's value in the competitive bidding process, and a caveat like that, I'm just not sure. I mean, it's certainly something to think about.
And then that one was actually expanded in a second question or second example. But an example that was given was computers from Dell direct at $479. Dell doesn't bid, and we pay $525 per computer. Can we then disqualify all bidders and purchase direct from Dell?
Dell has bid in the past, so the assertion that they don't bid isn't accurate. They have bid and can bid in the future. And you know, what we'd need to see in order for that claim to be verified is an apples-to-apples comparison of processing power and speed and delivery requirements and any incidentals included in that. So, I mean, I think that's the problem we get into a lot with these comparisons to the internet, is it's not always accurate. And I mean, without seeing the actual documentation for what's on contract and comparing that to what's actually being sold on the website, we just really can't tell. But the assertion that Dell doesn't bid is not accurate. They do bid. I've seen their bids before. Okay, so back to EOIs. The EOI template's been simplified. Again, we eliminated the cut and paste forms at the end. Evaluation criteria matches up with scoring, and the process has been outlined more clearly. The interested party disclosure form. I know you guys probably are well aware that for procurements of $100,000 or more, we were required to obtain the interested party disclosure form, and we got some significant pushback on that from the vendor community. A lot of times people go into business as a small business because they don't have to do a lot of the disclosures and things that publicly traded companies do, and you know, they want to keep it that way. And so we also had, you know, it slows down the procurement process when we have to go back and ask people to provide this form. And in general, there's just a lot of angst in the vendor community about having to fill this out. I had personally 3 calls from different vendors, complaining and asking why in the world they had to do this. And, the best answer she could give them is, well, the legislature passed a law, therefore, if you want to do business with the state, you have to. Based on a lot of the comments that we received over the last year, we approached the legislature and asked for, the ability to change that $100,000 limit to $1 million, and we're successful. So starting June 8th, the interested party disclosure form will not be required on contracts valued at $1 million or less, and it won't be required of publicly traded companies either, which is something that was not included in the prior version. You did have to for publicly traded companies under the old version. You don't moving forward. And the rationale for that was pretty easy. Under the SEC rules, publicly traded companies are publishing way more than what this form asked for already, and it's available on the SEC website. So it just didn't make a whole lot of sense to be slowing down solicitations for, that form. So hopefully that's going to make all of our lives a little bit easier. We'll have to get that form in less instances, and we'll be able to get to contract faster. Modifications, obviously the interested party disclosure form is being modified, as are the purchasing division terms and conditions to reflect that change. So what else are we doing? I mentioned we got together with a lot of agencies, a lot of interested parties, and said, how can we make purchasing better? What laws do we need to change? Well, the other thing that we did was ask ourselves, what can we change that doesn't require a law change? And we came up with quite a few ideas, so we're going to go through those now. This one, we hope, I would really hope this is very helpful to you guys. We're going to increase the verbal bid limit. Right now, it's $5,000. We're taking that up to $10,000. So between $2,501 to $10,000, that's the new verbal bid category, which also means that the written bid category goes from $10,000.01 to $25,000. So you'll be able to use the verbal bidding procedures in more instances. As I mentioned a minute ago, we live in a technology-driven world. Everybody, I assume, on this call has used Amazon at one point or another, or if not Amazon, some other website where you can click on an item, go to the shopping cart, and then purchase it. Well, the current verbal bid procedures didn't allow for that type of a purchase. It required verbal bids, and the verbal bids could not be a screen print. Well, that just, given where we're at today, doesn't make a whole lot of sense. So we kicked that idea around for a while and said, all right, if you can find it online and you can find it on a website that has the ability to sell it to you through that shopping cart, you can enter your information and get it right there and buy it, we will consider that screen print to be a verbal bid. Obviously, you can also buy it from them if they're the lowest verbal bid, but that screen print will qualify. And frankly, I think the screen print has a whole lot more provability than a verbal bid where somebody simply talks on the phone and writes down a bid number. So moving forward, you're going to be able to do that. Now, keep in mind when I explain that, it can't be a manufacturer's suggested retail page, right? It has to be a site that has the ability and willingness to sell it to you at that price you've taken a shot of. If you go to Ford's webpage and they say the MSRP for the truck is this, that's not it. That's not good enough. It actually has to be a website like Amazon, like Target, like Sam's Club, where you can go out there and actually purchase the item from there. And then also under delegated procurement, we created the WV65A form to allow agencies to better document those direct award purchases. And you would use that same form for verbal. Basically, on the sole source, anything 2,500 and up, you would do the WV65A and post it in OASIS and document. Publication time for direct award, it has to be advertised for 10 business days. And the same with solicitations. I'll just say, we've seen in several instances through, various methods that in some cases agencies are putting publication times of sometimes as short as a day. And guys, that frankly doesn't pass muster. I mean, the vendor community has not had enough time to see a solicitation or a sole source or a direct award posting in one day. So we've got to leave those out there for 10 days. That corresponds with your typical notice period and things like, you know, Class 2 legal ad. I mean, it just this 10-day timeline is the kind of the gold standard, so to speak. And so my question would be, why would you not, right? I mean, we need the vendor community to know about it so that we can get the best prices. So that's the requirement there. So what documents were modified at the delegated procurement level? Obviously, the procedures handbook, W65A, agency delegated direct award document was created, and that should be it. So something else that you know, we've been looking at for several years now is the contract term, the initial term, and kind of thinking about when and where does it make sense to have a longer term than just a simple, you know, 1 year plus renewals. And one area where we looked at and said that it makes complete sense is in the area of software and maintenance. In fact, we've seen several instances recently where the vendor, you know, sells you the software up front, and then they have 3-4 years of maintenance after that, except it cuts off at the end of every year. It gives that vendor an opportunity to say, no, I'm not going to re-up the maintenance this year. You're going to have to pay me more. That's happened to us at least twice. And so in order to combat that and to make all of our jobs a little bit easier, the initial, if you ask for a 5-year contract term on software, that's not even going to be a question. It's just going to be approved, right? With the understanding that that maintenance will be locked in for that period of time, whatever period of time you ask for, and the vendor's pricing will be solidified. What it does, it changes the conversation from the bidder saying, no, I'm not going to renew, I need to increase my price, to if you don't continue to hold your price for this contract term, you've breached the contract and there's going to be significant consequences. Insurance. You guys are probably working through this already, but we worked very closely with BRIM. You know, one of the things we've heard from agencies is that, hey, we're not experts in insurance. We don't know what the limits need to be. We're not sure what kind of, you know, coverages should be required of the vendor, and frankly, we're not experts in purchasing on that stuff either. And so we worked very closely with BRIM to try to come up with a way that we could provide that guidance to you guys and to us as well. And BRIM was very gracious in helping us with that. So one thing that BRIM has done is they've created an insurance guide that will explain what the various insurance policies do, and we're going to include that as an appendix in the handbook. So you'll see that coming out June 8th. Or actually, you know, I think it's already come out. I think Diane sent a preview to the procurement officer, so you probably have already seen that. The other thing we're doing is we need BRIM permission before we can publish a solicitation with no insurance. And then we've also received a recommendation. You know, we polled other states and talked to BRIM and asked, what are you guys doing on the additional insured question? Are you requiring vendors to list the state as an additional insured? And I think at least half of the states responded and said yes, they are. So you know, moving forward, we're going to want to see that terms and conditions have been modified to require that the state be listed as an additional insured. And BRIM said that, you know, in the past, the state of West Virginia actually required that. So at some point, and we're not sure why, that requirement was ended, but really the best practice is that we have that. So if you check out the terms and conditions, you'll see that that's in there, and we're going to be asking for it from the vendors. State Auditor's Office, as it relates to payment, you guys have probably seen recent email blasts from the Purchasing Division that the State Auditor's Office is trying to shift away from checks, writing checks. It's expensive. You know, it takes a lot of time and a lot of manpower to print those out. So they want to move the vendors to either payment by P-card or electronic funds transfer. You know, that's in the terms and conditions as well. But I think probably the most important thing to mention on that is that paying with P-card, paying by electronic funds transfer, that has absolutely no impact whatsoever on the procurement process and the requirements that you have to follow in order to solicit and obtain a contract. Paying P-card doesn't allow you to avoid the bidding procedures. It's just an easy way to send payment once those procurement procedures have been followed. Terms and conditions, one of the things that I personally did, I read through and kind of asked the question, you know, does all this detail need to be there? And in cases where it didn't, vendor preference for one, SWAM for another, we took out a lot of that information and will allow it to either live on the form that's associated with it in the case of vendor preference, or, you know, with SWAM, it's in the Code of State Rules. So just kind of eliminated some of that, the miscellaneous language that we included. And then on the performance bond, you know, there used to be a box where you could fill out an amount. In an overwhelming majority of the cases, the performance bond is listed at 100% of the contract value. In all construction contracts, it's listed at 100% of the contract value, so we just eliminated the ability to check anything other than 100% of contract value. BRIM was also instrumental in coming to that conclusion as well. So those two things changed. And, all right, we got another question.
Okay. If we are not asking for resident vendor preference, will SWAM go away?
So the way that there are multiple benefits to the SWAM program, and one, in federal procurement, if you're a SWAM vendor, you get certain benefits. And so the SWAM program sets up a mechanism by which West Virginia vendors can become certified as a small woman or minority-owned business. That's what SWAM stands for those of you who don't know. So the program will not go away in that sense. It will continue to exist and continue to serve that function of allowing in-state vendors and others to become, you know, SWAM certified. Additionally, because of the way the SWAM rules are written, we will be granting, so the way it reads is that a SWAM vendor gets the same preference offered to any in-state vendor. So the SWAM vendor, if there's a reciprocal preference in the solicitation given to a West Virginia vendor, the SWAM vendor gets that reciprocal preference as well. But we anticipate preference in general being a whole lot less utilized as we move forward, with the reduction in the straight vendor preference, and then reciprocal only applies in instances where the out-of-state vendor gets a preference. And I think more than half of the states do not have a vendor preference. So, and I was thinking that all of our neighbors did not, but we don't anticipate a whole lot of preference issues coming up.
We have about 10 minutes left, so if you have any questions, go ahead and type them into either the chat box or the Q&A box. Either one will work. Just be sure to send them to the host.
So we had a comment. One of the agency procurement officers said they had been advised that OASIS would check for both federal and state department. That's false. It will not. We've been told explicitly by WV OASIS that the system does not automatically check state-level departments. So you need to look at that every time you, before you award a contract.
And again, we'll wait just a couple of minutes as people type in their questions.
While we're on that as well, you guys have also been told by the Purchasing Division that you have to check the Secretary of State's website. That is also true. The problem that we've run into, and it's been a known problem for a while, the WV OASIS system, the communication with the Secretary of State's office isn't perfect, and so in instances where a vendor is not registered with that office and should be, the system will not tell you that that's incorrect. It will tell you if the vendor is already in the Secretary of State database and has been terminated for some reason or hasn't paid their annual fee, the system will flag that as a problem. But in instances where the vendor should be registered and is not, the system won't stop you. So those are two instances where the agency procurement officer and our central procurement officers are required to check the outside database. With the Secretary of State, it's the business organization database I was telling you about. With debarment, you have to check the state's website because you know, they're not done automatically.
Well, it doesn't look like we have any other questions at this time. If you do think of any questions, feel free to contact your designated purchasing division buyer. Again, the information that we discussed today will be posted on our website, including the handbook, all of the updated forms and templates. Additionally, anybody who was on today's webinar will receive an hour and a half of training credit towards your fiscal year 2018 training requirements. If you participated with somebody else by sitting at a computer with them, we will be sending out a certificate of completion that we'll need you to complete and submit back to us, just certifying your attendance in today's webinar. The link to the recording will be emailed to our designated procurement officers within the next couple of days, so be sure to share that link if there's somebody who could not participate in today's call. And with that, we will conclude today's presentation. Thank you very much.